All righty, joining us now on the Sports Parlor Podcast. He is the legal analyst for The Athletic. You've probably seen him everywhere, heard him everywhere. He's all over the place. He's absolutely crushing all of this stuff with Deshaun Watson, all the hearings. That's what we're here to talk to him about today. Daniel Wallach. Daniel, what's going on, man? Thanks so much for hopping on the show.
My pleasure. I don't know if I'm crushing it. It may seem like I'm all over the place, but it's very strategically placed. And the great thing about some of the podcasts and videos is that they live on forever on the internet. So the tape version of me is 24/7. The real life version of me just sort of pops in and pops out as the need arises.
Definitely. So, hey, I wanted to have you on the show. You know, the last how many ever months now, the podcast has really just been Phil Taylor and I going back and forth, speculating what's going on with this Deshaun Watson case. And I wanted to bring on an actual legal expert, somebody that's, you know, had boots on the ground with this type of thing to fill in our audience on what's going on with Deshaun Watson. If you could give us like a brief synopsis of what has happened.
Oh, no. My favorite question. Tell us the history of the universe from day one.
Up until this point, with
how much time? Go ahead.
You know, just like the stuff with Sue L. Robinson and everything, and kind of where the league is at right now.
Sure. Now, we've been speculating, you know, for the past year, it seems like what's going to happen with Deshaun Watson, because the NFL took its sweet time investigating the allegations. I mean, the first lawsuits, I believe, were filed in February of 2021, and we don't even get a hearing before Judge Robinson until June of 2022. So there's basically radio silence coming from the National Football League. So this issue has been God's gift to podcasters, not just Cleveland Browns podcasts, but Houston Texans themed podcasts, sports law podcasts. It has really been the sports law economic, revival act of 2022. So until there was an actual proceeding before a disciplinary officer, it seemed like it was repetitive. A lot of the speculation, how many lawsuits, why is the NFL taking so long? I got tired of it. I actually told my co-host on the podcast about a month ago, enough already with Deshaun Watson. Now, how many times are we going to do the same episode? Well, it's all repetitive until the hearing begins and until this goes to a formal proceeding with rules, with the standard of proof. And all these issues get crystallized for the first time when the prior 11 months, we weren't really focusing on the particulars of how the proceeding and the disciplinary aspect of it would work. So now we have basically new info, new material, and just like with Deflategate, with Ezekiel Elliott, with all these arbitration proceedings held under the auspices of the National Football League, you begin to hold them up to the light and scrutinize them a little bit more closely when there's an actual arbitration or an actual disciplinary proceeding. And thankfully, the league does at least a few things, not ideally, that gives us reason to say that even though the evidence may be problematic for Deshaun Watson, there's always some element of how the league has conducted things that gives the player a ray of hope. And in the Watson case, there are three factors. There's the burden of proof, which for Ezekiel Elliott, for a violation of the personal conduct policy, was credible evidence. I don't know how it went from credible evidence to a preponderance of the evidence. And for those in the audience who aren't lawyers, credible evidence is simply any strand of evidence that would support the finding, whereas a preponderance of the evidence is a showing that it's more likely than not, more probable than not, that the accused player committed the alleged offense. So that's a major step up in just the evidentiary showing that the league has to make here, one that they didn't even try to make in Ezekiel Elliott. So I'm a little bit surprised that the NFL acquiesced to that. I think they had to. And I wrote a deep dive on that issue for my website, Conduct Detrimental, a week and a half ago. And that same day it was published, I think a reporter for CBS Sports made an inquiry of the NFL, and they said, yes, it's preponderance of the evidence. So when you combine that, a higher standard of proof that's not even addressed in the CBA, the absence of live witness testimony. I mean, if you're trying to win a case by a preponderance of the evidence, it would certainly help to have your victims tell their stories in court. And it doesn't quite read the same way to selectively pick out, pieces of a transcript or a summary of the evidence. You want the real person. And of course, the NFL does have its own sordid track record of not disciplining league owners, league officials, league executives when they're faced with the same or similar allegations of misconduct. I mean, Jerry Jones was sued over an alleged act of sexual misconduct once or twice. No discipline, not even a league investigation. Robert Kraft was arrested for frequenting he engaged the services of a prostitute in a massage parlor in Palm Beach County. Not exactly something worthy of the firing squad, but not exactly so separated from what Watson is accused of. Maybe the number of incidents or the recurring nature of what Watson's accused of lend added gravity to the situation. But I mean, Robert Kraft was charged with a crime. He was indicted by a grand jury. Sure, he got off the hook based on the fact that the evidence that was procured, the videotape, electronic surveillance, was deemed inadmissible and thrown out as a result of an appellate ruling. But it doesn't, as the NFL is fond of saying, the outcome in a criminal proceeding does not bind us in our own investigation to see whether the league personal conduct policy was violated. And the league has stated in its own policy that they hold the owners to a higher standard and traditionally not will, but have held them to that higher standard. And that just simply hasn't happened here. So when we begin to hold things up to the light and look a little bit more closely, there are some problems with the NFL's case relative to its burden of proof, lack of live testimony, and its conduct with other cases.
Daniel, with everything that you said, I think there's a piece of me and there's a piece of every Browns fan out there that's like, man, it sounds like, Watson has a chance. And like you said in there, a glimmer of hope and a beam of hope for the player. But at the end of this, what would you say to the people that are like, yeah, but it's still the NFL and they could do whatever they want? Because we saw that with Brady and with Deflategate when they had to, take it to a federal jury in a federal court, and that it upheld the NFL's decision, pretty much saying that the NFL could do whatever they want.
Well, it's not that the NFL can do whatever they want. This is now in the hands of a neutral disciplinary officer.
Right.
So you're talking about a federal judge who's going to be presented with evidence from 5 separate alleged incidents involving Deshaun Watson and 5 massage therapists. There's witness testimony, or at least transcribed testimony. There's evidence. There's investigative reports. There is some evidence before this judge. So it's, to talk about it in terms of, a ray of hope for Browns fans, I don't want to minimize the gravity of an alleged sexual offense or sexual misconduct here. But I think it's also telling that there wasn't a criminal case. 2 different grand juries were presented with evidence and elected not to return an indictment. There were no police reports even filed around the time of these alleged incidents. They only came to light when a plaintiff's attorney began to sign up these women and file 24, 25 lawsuits. So I'm not going to suggest that failure to report or a lack of a grand jury indictment negates the possibility that this thing happened. So I don't think that this is an easy decision for Judge Robinson, but certainly the burden of proof, while it's higher than it had previously been, at least for the Ezekiel Elliott case, it's low enough where, based on the evidence that has likely been marshaled in this case, she likely will find him to have been in violation of the personal conduct policy, at least with respect to several of the complainers or complainants. I don't know. We're not in that hearing room. We haven't seen the evidence.
Right.
But based on what we know and what's been reported over the last 2 or so years, it's difficult to think that this hasn't happened, that the allegations that caused the Houston Texans to settle 30 lawsuits and for Deshaun Watson to settle 21 out of 25 lawsuits collectively to the tune of multi-millions of dollars is a frivolous lawsuit. There's clearly something that happened. And the question is whether Judge Robinson will believe that a preponderance of the evidence shows that he committed some act of sexual misconduct. And if so, what's the penalty that she's going to impose? And she's going to have to make that assessment, not in one case, but in 4 or 5 different cases. So I think looking at this, if I was reading tea leaves without being in the room hearing the evidence, I would be surprised if no suspension or no discipline is levied here. I expect something.
Yeah.
Given the sheer number of cases, the number of settlements, and even some of the testimony that was included in the first lawsuit filed against the Houston Texans. Tony Busby, brought receipts, deposition testimony, and evidence that probably is included within the Deshaun Watson disciplinary case. That's just probably the tip of the iceberg. So for me, the issue is, can she write an opinion that would convince or allow the parties to accept it without taking a further appeal? Because if she levies anything, the NFL can run to the races and basically have carte blanche to raise it to any level they want, because that's what the players agreed to in the CBA. As unwise as it is, and as much as it makes a mockery of the judge's decision-making in the first phase of the case, the CBA expressly grants Roger Goodell the ability to modify the discipline upwards or downwards based on the evidence presented, without according any deference to Judge Robinson's decision, other than respecting her finding that there was a violation.
Yeah. And I think that's the tough part for a lot of fans to swallow right now. Like you said, leave, the actual allegations and everything out of it, just the people trying to figure out, when is this guy going to be on the field? It's like, man, if she finds any issue, say she gives a 1-game suspension. I know that's not going to be the suggestion, but just in a hypothetical world, they could come back and say, no, it's going to be a full season, which is ultimately what we've heard that the league is pushing for.
But it makes the league
look
like they're not respecting the credibility and wisdom of a federal judge who served on the bench in Delaware for more than a quarter of a century. Before that, she was a magistrate judge. And to go from a less severe suspension where she finds that there are no acts of violence, threats of coercion, and that she supports all these reasons for, let's say, a 4-game or 6-game suspension, for the NFL then to take that and say a year indefinite suspension, they're simply just utilizing or invoking their recommendation to begin with, and making ultimately negating all the time the judge spent to weigh the evidence and find an appropriate level of discipline. It essentially means the NFL is going to do whatever it wants to do, so long as the disciplinary officer imposes some discipline. And for the league to then ignore the judge's recommendation and depart so wildly from it, from 2 games to 1 year, it would leave the league open to criticism that they're simply nullifying Judge Robinson's decision. And it could create vulnerability in the federal court system, because under the Deflategate ruling from 5 or 6 years ago, the Second Circuit U.S. Court of Appeals said that we're not going to interfere with an NFL arbitration ruling on discipline so long as the arbitrator, in this case Goodell, acted within the scope of his authority. That's all it is. It's not an invitation to reweigh the evidence. The only out for a federal court would be, or the main out would be, the notion that the NFL is imposing, and I'm using the precise language from Deflategate, if the NFL is imposing its own brand of industrial justice, then you might see the federal courts vacate that arbitration ruling, lengthening the punishment. Because if a federal judge who's respected is imposing a 4-game, and then the league on appeal rubber stamps its original recommendation, it makes the original disciplinary proceeding look nothing more than a kangaroo court. And what the NFL is doing is simply imposing its own sense of industrial justice based upon its original recommendation. So if the league does that, they could breathe life into a potential Deshaun Watson lawsuit. And that's the risk that the NFL has here by going too heavy-handed and swinging or departing so wildly from Judge Robinson's decision. It could make the league's appellate ruling more vulnerable to attack in federal court.
What do you think are the odds? Obviously, we're playing a dangerous game here. We're recording this interview on a Monday. This podcast comes out on a Thursday. What do you think are the odds that, a settlement could happen at some point? And, Deshaun Watson and the NFL don't even give Judge Robinson an opportunity to make her ruling, and they just settle on a mutually agreed amount of games.
I think she's hinting that she would prefer that, actually.
Yeah, and I would too. If I was her, man, I'd be doing the same thing. Just saying.
Well, here's why. Under Article 46, once a hearing concludes, both sides have 3 days to file post-hearing briefs. She gave both sides 12 days. I mean, a large part of that may be on account of the 4th of July holiday weekend, but she did give the parties lots of extra time. And it raises the question, or at least begs the question, is she leaving enough runway here for the parties to talk and reach some kind of a middle ground? Now, the difficult thing for the NFL in reaching a settlement is if it's less than 1 year, they may face somewhat of a criticism from those corners of the universe that think that that Deshaun Watson committed not just a horrible act, but a series of horrible acts, and that he's a serial sexual assaulter. So the league is going to face criticism, no matter what it does, under disciplining, over disciplining. And from the league's vantage point, the best call here would be to allow Judge Robinson, an experienced longtime federal judge, to basically take the heat on that and make the decision and allocate the responsibility for arriving at the appropriate number to Judge Robinson, because if the league tries to do it, they're not going to win. Either it's too light or it's too heavy. Yep. So there's probably some momentum, or at least some preference, for having Judge Robinson do the league's quote unquote dirty work, even though she's not doing the league's dirty work. She's arriving at a decision, but it's easier for the league in terms of not having to face accountability if it's her decision rather than the league's decision. So maybe secretly, if you gave the NFL lawyers some truth serum, and you told them that Judge Robinson was going to issue an 8-game suspension, maybe they're okay with that. Yeah. But outwardly and publicly, they're not going to be.
Yeah. That's
so it's incumbent on her to find the right balance to impose a level of punishment, if she's going to impose any discipline, that leaves both sides unwilling to take a further appeal or not wanting to take a further appeal.
Definitely. To wrap this thing up, I'm not going to make you give your prediction on how many games Deshaun Watson's going to miss. I actually want to know, how, for you personally, does this case stack up in some of the other high-profile cases that you've covered? I know the big one has to be probably Deflategate, right? Just as an ignorant eye, looking in, that was huge.
I would say in rank, it would, at least so far. I mean, there's an incomplete grade on the Watson case because it hasn't gone to a federal court case yet. So until it goes, or if it goes to a federal court case, it has an incomplete grade. And at this level, when it's gone to a private disciplinary hearing before an internal officer where there's no transparency around the proceedings, it obviously can't be on the level of Deflategate or the Ezekiel Elliott disciplinary case, which traversed, I think, 3 different federal court judges. I think there were like 4 or 5 decisions in that case, because Jeffrey Kessler and the NFLPA originally filed suit in the Eastern District of Texas. The case went on appeal to the Fifth Circuit. There were 2 hearings in the Texas federal court. Then there were 2 hearings in the New York Southern District Court. That had like this bi-coastal element to it, where there was one result, Elliott kept winning, and then the case got transferred, Elliott won again, and then ultimately the judge who was permanently assigned to the case ended up ruling in the NFL's favor. So in both Elliott and Deflategate, you had multiple court rulings and initial victories for the player,
right,
only to have those victories snatched away by a subsequent court ruling. And you had all this, all these elements of challenging, the NFL was hiding or preventing the Players Association from gaining access to the evidence. We were a lot deeper into the notions of the league playing fast and loose with the evidence, and preventing the Players Association from having a level playing field in terms of taking depositions, cross-examining witnesses. There was a lot meatier stuff in dealing with those other two cases. But with Deshaun Watson, I would say it's a fast riser. What was probably a non-eventful but endless legal controversy all of a sudden became, rising with a bullet over the last couple of weeks because of all the intrigue surrounding the disciplinary hearing. Now we have the possibility of an appeal, a federal court lawsuit, and then after all that is over, we can evaluate Deshaun Watson's place in NFL sports law history. But until that point has arrived, there's just too much, that still has to take place before properly assessing where it stands. So the grade is incomplete.
All right. That's completely fair. In the meantime, tell everybody where they can go follow you. Like you said, I know you've covered this in so much greater detail than what we were able to get through on this podcast. Where can everybody go check out all the content that you're putting out?
My website, conductdetrimental.com. That's the terminology utilized in Article 46, Conduct Detrimental. That's the name of my podcast, which I co-host with another sports law expert by the name of Daniel Lust, Dan Lust, great name. So the two Dans co-host Conduct Detrimental. We have episodes once a week or twice a week. And this week we expect to have, I don't want to spoil the surprise, but we have a leading national NFL writer. Awesome. And unsurprisingly, we're going to be covering the Deshaun Watson stuff.
Look at that.
And us on Twitter, you can follow me at Wallach Legal.
Cool. Thank you so much for hopping on this, and go give his podcast, a listen. It's taught me so much, and it's been the only thing keeping me afloat throughout these last couple of weeks with all this Deshaun Watson stuff. So Daniel, thank you so much for hopping on. I appreciate it.